announcements.
Honourable members, I have 2 points to raise at the beginning of today's sitting. By virtue of Standing Order 17.2, I have the power to allow the order of business set out on the order paper to be altered in respect of any particular sitting. After consultation, I have therefore decided that for today, the second reading of the public bill will be taken as item 6 before we resume the debate on the motion on the government programme. The second point, members, I would like to tell you that it's now been a little bit more than 2 months since we all were sworn in, including myself as Speaker of this Assembly. And I suppose we don't all, including me, master all the proceedings of the Assembly, the intricacies of the procedures of our Assembly. One principle, however, that I do know, and I'm sure that most of you, maybe some of the newcomers, do not yet realize, a member is not allowed to read a statement when we are debating an issue, including on the motion, and will be the same for the bill, except the person who has been chosen to make the main speech, like the honourable member did. And of course, I didn't stop her because the standing order is quite clear on this. Let me myself read. You can read when you're citing. So I'm going to read because I'm going to cite you Standing Order 39.9. A member shall not read his or her speech, but he or she may read extracts from written or printed papers in support of his or her arguments and may refresh his or her memory by reference to notes. Reading of speeches is permitted for opening addresses. It was in this spirit, therefore, that I allowed Honourable Second Member for Quartier Militaire and Mocha to read her speech. But several members, I think, tended to read their prepared speeches. Of course, it's always easier. I also want to draw your attention to Standing Order 40, subsection 1 and 2. 41. A member shall confine his or her observations to the subject matter under discussion and may not introduce matter not relevant thereto. I prefer to say it now rather than stop you. 42, it shall be out of order to use unbecoming words or expressions or to use offensive language about members of the Assembly, on whichever side. So I hope, members, that you will help me in maintaining the high standard expected of such an august assembly as ours. I promised you when I was sworn in that I would uphold the dignity of the National Assembly. Remember also that children and adults are watching us both from Mauritius and from abroad. Thank you very much.
Papers have been laid. Question.
Honourable Leader of the Opposition.
Thank you, Madam Speaker. Madam Speaker, I've given notice of the following private notice question addressed to the Honourable Minister for Land Transport, whether in regard to road safety and the current situation on our roads, he will, A, for the benefit of the House, obtain for the period 1st January 2025 to date, information as to the number of 1, reported cases of road accidents, including the types of vehicles involved and the number of fatalities. 2, contravention issued indicating in each case the offences committed. B, state the number of speed cameras currently not operational, indicating the regions thereof. And C, state the measures presently being taken to address the increasing number of road accidents?
Madam Speaker, I wish to thank the Honourable Leader of Opposition for this PNQ, which provides me the opportunity to address the House on road safety, which is a subject of national concern. Since this government has taken office, the issue of road safety, including road accidents, is central to its priorities. Madam Speaker, as announced in the government programme 2025-2029, government will come up with a 20-year strategic master plan which will provide a strategic orientation for the land transport sector. The master plan will also include walkability into the country's larger mobility strategy that connects seamlessly with public and private transport and cycling infrastructure. This will reduce dependency on vehicles and therefore lessen the risk of road accidents. As government expands and modernizes the land transport, it will also ensure greater road safety by introducing a graduated licensing system, which was announced in the government program, undertaking projects to eliminate risk-prone spots and enhancing enforcement and road safety education. I shall come up to these issues later on in my reply. Madam Speaker, if we are in the current situation today, it is because of the contradictory policies of the previous government. In line with the UN Decade of Action in National Road Safety Strategy 2016-2025, with the objective of decreasing the number of fatal and serious accidents by 50%, had been adopted, but the target had not been met. It is an obvious failure of the previous government. I have already caused a new 5-year national road safety strategy to be elaborated and will be finalized during the course of this year. Why I say contradictory policies, Madam Speaker, is that over the last 10 years, there was a complete relaxation and leniency on enforcement on road safety, with very negative impact on our roads and road users. We are today observing havoc on our roads, and I must say, the Honourable Leader of Opposition, who is an influential member of the then government, was and is still in his party, that his party did nothing much to improve on road safety. Over the last 10 years, the number of fatalities was 1,482, and this is alarming for our country. One death is too many. The blunder committed by the previous government is that it cancelled the penalty point system, PME à point, in the wake of the promises made in the electoral campaign 2014. The cancellation was surely for political reasons, without any rational and solid scientific reasons. Incidentally, one former police officer, highly knowledgeable in the field of road safety, Mr. BM, he's a public figure, Mr. Baden Munsami, publicly stated yesterday on Radio Plus that PME à point, introduced in 2013 by the Labour government, led to a positive result in terms of improved behaviour of drivers and motorcyclists. I wish to inform the House that with the PME à point system, the number of fatal road accidents decreased from 156 in year 2012 to 136 in 2013, showing the effectiveness of that system. With the PME à point system, there was a culture of cautious driving on our roads by all vehicles, including motorcyclists. Madam Speaker, with the abolition of the PME à point, which led to a lot of reckless driving on our roads, the previous government introduced the Cumulative Road Traffic Offence, CRTO, with only 11 offences. The number of offences were increased to 2,023 in June 2024. However, my predecessor did not cause the proclamation thereof, and he has to provide an explanation to the people of Mauritius on this shortcoming. I can only guess that the reason for this yet political That is, not to lose popularity at the eve of the last general elections, therefore putting the life of people at risk on our roads, just like the cancellation of the permis à point. Not promulgating the penalties for auto and motorcycle for their safety has rendered the public more vulnerable on our roads. These include failing to wear high visibility clothing, failing to overtake traffic on the right, riding a motorcycle abreast of another two-wheel vehicle. Very valid proposition, but unfortunately not implemented due to political reasons and the fear of losing popularity at the eve of general elections, like I just mentioned earlier. Madam Speaker, in regard to part A1 of the question, I am informed by the Commissioner of Police that there were 579 road accidents, including 14 fatal road crashes, causing 17 deaths for periods starting 1st January 2025 to 6th February 2026. The type of vehicles involved in the fatal accidents are 9 cars, 6 heavy good vehicles, 1 bus, and 11 two-wheelers. Regarding part A2 of the question, I am informed that the Commissioner of Police is compiling the number of contraventions issued for period 1st January 2025 till date and along the categories of offences. The information will also be tabled. However, I can provide figures for the last day of 2024, that is 31st December 2024, and the first day of 2025, meaning 1st January 2025, whereby there were 441 contraventions, out of which 17 were for drink driving and 150 for overspeeding. Drink and particularly drug driving is a matter of concern, and the Honourable Prime Minister has recently, last Tuesday, replied on the drug driving aspect in his reply to PQB number 3 of Honourable Kirin, during which he provided information on road accidents from 1st January 2024 to date and measures being taken by the police thereto, including number of fatal road accidents and measures being taken by the police to deter the use of drugs by drivers. Madam Speaker, as regards part B of the question, I am informed that there is a network of 63 fixed speed cameras installed on our roads around the island, out of which 4 are currently not operational, 4 out of 63, at the following locations: Saint-Julien, Calbas on motorway M2, Brisé-Verdier, and Cas-Noyal. I am informed by the TRMSU that not a single speed camera was procured by the previous government. All they did was to relocate 4 existing cameras and have 4 dummy sites instead, dummy cameras. I wonder why putting in the question, the leader, I wonder whether in putting this question, the leader of the opposition was even aware about these facts. Coming back to these 4 defective speed cameras that have been sent to the manufacturer Truvelo UK at the end of January 2025 for diagnosis and repairs are expected to be operational by April 2025. It is a matter of great concern, Madam Speaker, that immediately after the 2014 general elections, and as promised, the MSM-led government switched off all the cameras, speed cameras, over a period of 7 months. This was indeed a reckless and irresponsible decision of putting the lives of people of our population at risk. Madam Speaker, I wish to inform the House that the TRMSU, Traffic Management and Road Safety Unit of my ministry, has embarked onto a consultancy exercise that seeks to revamp the whole speed camera system, whereby a new photographic and video camera detection system will be implemented as a matter of priority for enhancement of road safety violations in Mauritius, being given that the speed camera system dates back to more than 10 years, and according to the unit, meaning the TRMSU, is no more responsive to the current international road safety requirements. The whole system will be holistically looked into and not on a piecemeal approach, and will cover all other offences like red light violations, non-wearing of seatbelts apart from speeding. Madam Speaker, with regard to part C of the question, I wish to inform the House of the measures being taken by my ministry to address the rising number of road accidents. Number 1, immediate review of road safety policies with focus on reduction of road accidents. Number 2, assistance will be sought from the UN Special Envoy for Road Safety, Mr. Jean Todt, to improve our road safety. This is an initiative of the Honourable Prime Minister in due course. Number 3, conversion of other highways from single to dual carriageway where needed, as was the case for the La Vigie to SSR International Airport, implemented under the leadership of our Prime Minister. The House and the population will recall how this road was prone to accidents before this conversion. Number 4, adoption of a global approach to road safety instead of a piecemeal approach as carried out by the previous government. Number 5, revisiting the whole system of granting of driving licenses by the police to make our drivers more skillful and responsible on the road by introducing a graduated licensing system aiming to provide drivers and riders with specific knowledge, skills and driving experience gradually over time in a mix of training environment. The graduated licensing system will comprise 4 phases, namely a pre-licensing phase, a learner licensing phase, a probationary licensing phase, and a post-licensing phase. Number 6, reconstitution of the board of the National Road Safety Council with experts in the field of road safety. Under the chair of the previous chairperson, under the previous government, Mr. A.G., well-known person, only 9 meetings were held during his tenure of office, I'm informed. And he did not succeed to have the support of his members, and meetings had to be cancelled time and again because of lack of quorum. Today, we are paying a high price for this inaction. Number 7, finalization of the curriculum for implementing of road safety education in secondary schools. The program will be launched shortly. In the same vein, the Ministry of Education and Human Resources has been requested to undertake an assessment on the road safety knowledge imparted to primary school students for the cohort of grade 6 this year. Number 8, elimination of the 5 accident black spots locations in the country through appropriate re-engineering works over the next 5 years. Some additional 300 kilometers of road will be rehabilitated to enhance road safety standards, as these roads are hazardous to road users. Number 9, working together with the traffic branch of the police to enhance enforcement on road, supported by the proposed new PME Appoint system. Number 10, revamping of the TRMSU into a National Road Safety and Traffic Lead Agency, a dedicated institution for road safety that will implement national strategies for reduction of road-related fatalities. Number 11, modeling of traffic jams throughout the country so as to propose remedial measures which will enhance traffic flow, and in the same vein, road safety. The support of drone technology will be used to make the modeling more effective. Number 12, carrying out an extensive survey island-wide with a view to assessing the state of the road traffic signs and road markings. Where needed, we would reinstate all road signs and marking. This was neglected over the last 10 years. I have time and again been receiving complaints from my colleague MPs to go to their individual constituencies. Number 14, increasing of penalties for road traffic offences. Those not wearing retroflective vests will be taken to the police station. This is a proposition concerned, and will be only allowed back on the road if the rider obtains the prescribed retrospective vest. I believe amendment will have to be made to the law. Introduction of legislation, number 15, introduction of legislation to make it compulsory to use child restraint devices in vehicles where applicable. And last but not least, number 16, working together with the Ministry of Education and the MITD for the revamping of the Professional Driving Training Center into a modern one with international norms. Madam Speaker, I launched a sensitive campaign on drink and drug driving on 24 December 2024, ahead of the festive season. I have personally participated in crackdown operation conducted by the traffic branch of the police at Gambé, known for being a high-risk area in view of being a major tourist and entertainment locality. I also participated in the distribution of reflective vests to sensitize motorist riders. Comprehensive programs to improve road user behavior would be developed and implemented along with public awareness and education to increase seat and helmet wearing, and to discourage speeding, among others. This government, Madam Speaker, is much more committed than the previous one to bringing necessary changes to enhance road safety and build a culture of responsible driving so as to manage road accidents in the country. And in this respect, the Honourable Prime Minister has stated foreign expertise will be sought when needed. Thank you.
Thank you, Minister. Leader of the Opposition.
Thank you, Madam Speaker. I thank the Honourable Minister for his reply. This is a matter of national interest, and the number of fatal accidents since the beginning of this year is quite alarming. Can I ask the Honourable Minister to inform the House whether he has chaired a crisis committee with all stakeholders to address this issue of road accidents, and if yes, what has been the outcome?
Speaker, I have had meetings with many stakeholders, including the police, which is the main one. But like I said earlier, the National Road Safety Council is being constituted, and once constituted with the right person at its head, unlike the previous one, which shared only 9 meetings in his tenure of office, we will crack the way forward on this very important issue.
Thank you. Leader of the Opposition.
Yeah, my question was whether the Honourable Minister himself chaired a crisis committee. With regard to illegal rally of motorcycles, I believe the Honourable Minister is aware that in certain regions of the country, particularly at night, there are some illegal rallies taking place, and I can mention 2 places I know. One is within the Jinfei area, and very often along the highway between Rochebois and Terre Rouge. Can the Honourable Minister inform the House whether deterrent measures have been put in place since the month of December, and the outcome thereof, and what measures are being taken to prevent these illegal rallies at night?
Yes, Madam Speaker, this is really a problem, and it is not new. It has been going on for quite some time now, and the law has been amended, as the Honourable Minister would know himself, in June 2024, but like I said earlier, it was never proclaimed.
Oh.
So, this is the issue. So, we undertake to do it, Madam Speaker.
Is the Minister, I believe he must be aware that our youngsters participate in these illegal rallies because there are huge sums of money involved. And most of these rallies sometimes are organized by drug lords, Madam Speaker. Is his ministry looking into that issue also, and what measures are being taken to prevent that?
Yes, I believe the police is doing the needful. I believe the police is doing the needful on this. I will again talk to the Commissioner of Police. But like I said, the Achilles heel in this whole system is that currently the police is not empowered with the law to crack down on this illegal operation because my predecessor did never promulgate the law. I have to stress on this point because the previous government struck a balance between popularity and road safety, and popularity prevailed over road safety, and this is why we are in this sorrow state of affairs today.
Now, Speaker, his predecessor is no more sitting in that office. He is sitting in that office now. Madam Speaker, may I ask the Honourable Minister whether he is aware that most of those vehicles that participate in those rallies have their engines modified to increase their performance. Can the Honourable Minister inform the House what operations have been carried out by his ministry to crack down those involved in these illegal modifications of those engines?
Okay.
Now, this is an important question. And for this one, a Cartesian approach is warranted, Madam Speaker. You know why? We cannot possibly control every cars and motorcycles that is being modified in the country. But those garages that are doing these modifications, they will be the one that police will have to check on them. And if they are doing it, I'm sure, illegally, because permits are required for this kind of modification, we will definitely take action against them. So a Cartesian approach rather than an individual approach in this case is warranted.
Yes.
Thank you, Madam Speaker. In his reply, the Honourable Minister mentioned that his ministry is reviewing the National Road Safety Strategy. This is what you said in your reply. Can we know what are the main components that would be reviewed in the National Road Safety Strategy?
Yes. In fact, there are a lot of issues to be looked into. I had a meeting with the UN. I had a meeting with the UN office here, and then a holistic approach will have to be taken in this respect. So the issues that will have to be taken into consideration while I'm waiting, it's very technical. It's a very technical ministry, Honorable Lejonga, and I've been at this office for 2.5 months. So I'll give you the points exactly. So we will look at the 3 A's, which are important in this respect. The first one is engineering. Our roads and the vehicles, as he has just mentioned, enforcement by the police, and perpetual education. This is important because our kids, right from school, have to be taught road safety principles. Sensitization is also one of them. We've done it in the last December. And post-crash care, this is also important. So among all the issues that we have to take on board in this strategy, I've listed a few for as you requested for.
Honourable Duval.
Yes, thank you, Madam Speaker. May I ask the Minister, we've seen a visual degradation, gradual degradation with regards to particularly motorcycles, not wearing high visibility vests, not wearing helmets, and of course modified exhaust, especially in coastal villages. And we've seen that police posted at local police station are now powerless and in fact have given up on enforcing road traffic. Can I ask the Minister whether he will consult with the Commissioner of Police and ensure that specialized police units are posted from time to time along these places to ensure that those persons who are usually people who are on record, who post bail, etc., that he takes them to task. This is a major issue.
Madam Speaker, the main cause of accidents are the following. Reckless driving and not respecting the law.
I still can't hear you very well.
Reckless driving is the first one.
Yes.
And this includes speeding,
Yes.
drink and drug driving, and use of mobile phones many a times in the car and motorbikes. I've seen, Madam Speaker, a mother carrying his child on a motorbike without a helmet and while the mother was on the phone. These things happen. So the member has mentioned about reflective jacket. I've mentioned in my initial reply that we intend to change the law because many at times motorcyclists after 6 o'clock at night where it is mandatory to wear a reflective jacket, do not wear, because they don't seem to bother. And that sometimes a jacket is with them, sometimes it's not. So we are proposing to fine them, as it is being done right now, and perhaps even more. And if they are not in possession of a jacket, to have their motorcycle escorted to the police station, and they come and take it once they have come with a reflective jacket. This will make them think twice before embarking on their ride without a jacket. The honourable member has mentioned about illegal modification of motorbikes. The Cartesian approach will apply to this one as well, at the garages instead of individual motorbikes.
The member over there, please.
A number of road accidents are caused by the fact that some traffic lights in strategic parts of the island have not been operational for months now. I can personally cite two examples, one at Sigoulam-Tourol Government School in Rosebel, and the second one near Pont-Colville Mosque in Nouvelle-France. Would the Minister consider the advisability of having the TMRSU carrying out an audit of those traffic lights which are not operational and see to it that the needful is done for them to be fixed?
We've had issues of traffic lights already.
Yeah.
Please.
But I will just remind the honourable member what I had said to Honourable Anquetil. We are aware of all the traffic lights that are faulty. The Traffic Management and Road Safety Unit has the list. But the problem is my predecessor, again, I'm told, has consumed all the budget there was before my arrival of the ministry. So I have to make a fresh application for funds, and this is being done. And this is being done in the interest of road safety. But I must say that many at times those traffic lights are faulty because, like I explained the other day, the trunking underneath the road is jammed. It's defective. It's full of mud for poor work that was done in the past, and civil works are warranted, and this is very costly in order to replace those cables that are giving false signals and no signals at times.
Okay, very important question. So, Leader of the Opposition, your last question, and then... Well, 3 minutes left.
Let me get to the graduated licensing system. The Honourable Minister talked of reintroduction of that system. Will the Honourable Minister assure the House that proper consultations will be held with relevant stakeholders, that is, lorry drivers, taxi drivers, bus conductors, before the introduction of the system?
As a matter of fact, Madam Speaker, the whole National Road Safety Strategy and Action Plan will be implemented in a bottom-up approach, therefore fully participative.
Thank you for a brief answer. Peut-être il y a encore une minute. Yes, let the Leader of the Opposition.
Thank you, Madam Speaker. May I ask the Honourable Minister whether he can give due consideration to the use of safe city cameras for traffic offenders, to control traffic offenders?
Like I said earlier, what I can reply for sure, the new speed cameras that will be implemented, because the last ones are more than 10 years old and maybe need to be revised, will comprise these features. But whether the safe city camera can have these features is a very technical question. I can take it up with the Commissioner of Police.
Thank you. Last minute. I have one last minute, yes?
The Minister has spoken about the modification of vehicles, engines, etc., which gives extra power to vehicles. Will the Minister please consider the possibility of fitness centers having the adequate equipment to monitor the horsepower of vehicles which are modified, which can be deprived of the fitness certificate, and these vehicles are the ones that are being used for those illegal rallies and cause accidents?
Yes. The law will have to be modified. As it is now, only 7-year-old vehicle that goes to fitness centers. But then those modifiers of vehicles, they are very clever. Before they go, they will remove the system for them not to be penalized. That is why I favor the Cartesian approach. going at the garages that do the modification and pinch them there itself.
Time is up. Time is up. I've been very patient and very fair. I think we should stop. We've got a very long night ahead, not to say morning.
Motion.
Madam Speaker, I'd like to move that all the business on today's order paper be exempted from the provisions of paragraph 2, Standing Order 10.
Yes, the question is that all the business on today's paper be exempted from the provisions of paragraph 2 of Standing Order 10. Those in favour say aye. Those against say no. The ayes have it.
Statement by Ministers, none. Public Bill, second reading.
I move that the Financial Crimes Commission Miscellaneous Provisions Bill No. 1 of 2025 be read a second time. Madam Speaker, today I rise before this august assembly to present the Financial Crimes Commission Miscellaneous Provisions Bill No. 1 of 2025, a measure that is much about legal rectification as it is about the restoration of our nation's fundamental principles: democracy, constitutionalism, and the rule of law. This bill is not merely a technical amendment to an errant statute. It is an unequivocal statement of the new government elected by the people with a mandate to restore democracy, that it will not tolerate legal aberrations that corrode the integrity of our constitutional order. What we seek to do today is re-establish the proper balance between the branches of government, fortify the sanctity of our institutions, and reverse the legislative vandalism that was perpetrated in a manner both reckless and unconstitutional. Honourable members will remember and recall that when the Financial Crimes Commission Act 2023 was passed last year, it was widely criticised for purporting to confer on the FCC powers that directly violated the Constitution, powers that encroached upon the prosecutorial powers and role that our supreme law reserves for the Director of Public Prosecutions, and for the Director alone. This was no oversight, nor was it a mere error of judgment. It was a deliberate and calculated attack on the prosecutorial independence enshrined in our legal system. It was a move to open our criminal justice system to insidious political interference. Indeed, I can today inform the House that the version of that bill that was enacted in 2023 was not the version that had been submitted to the Director of Public Prosecutions for his initial views. It was not the version that the DPP had agreed to. No, it was a version that was further tweaked and twisted, and to which the learned DPP raised serious constitutional objections. Thus, Madam Speaker, the DPP himself had no choice but to seek constitutional redress before the Supreme Court, challenging the blatant encroachment upon his domain. And here we must pause to reflect on a truth that too often is neglected these days. That is, the law can only function effectively if those entrusted with its enforcement uphold their duties with integrity and independence. The Constitution provides, Madam Speaker, for several independent institutions, from the Commissioner of Police to the Public Service Commission. But how many of these actually operate independently at all times? To his credit, the learned DPP acted to defend the role attributed to him by our Supreme Law. And in undermining the DPP, the previous government did not merely violate the Constitution, they committed a graver offence. They undermined the very foundation of justice. Madam Speaker, let me be absolutely clear on why this is so egregious. Our democracy is built upon the principle of separation of powers. Those who make the laws must never be the ones who administer justice. This principle is deeply ingrained in our national ethos, forged through centuries of democratic struggle to end the absolutism of despots, where rulers once held unchecked powers as judge, jury, and executioners. Madam Speaker, one does not need to have read Montesquieu to grasp that something would be profoundly wrong if tomorrow a minister were to preside over cases at the Intermediate Court, for example, or if a Prime Minister were to interfere in the conduct of a judicial inquiry. However, some in this country still fail to grasp the danger of placing prosecutorial powers under political control. They argue rather simplistically, I must say, isn't the DPP part of the executive in any case? What is the problem if suspected offenders are brought to justice through government action, they ask? After all, independent judges and magistrates will ultimately decide the case. These are probably the same persons who in recent weeks have been demanding, why has the new government not yet arrested X or Y? Why has not been X or Y been prosecuted for this or that offence? To them I say this is not how our system works. If it were, and the government had the power to direct criminal investigations and prosecutions, two grave risks would threaten our nation. Firstly, individuals could be targeted for prosecution based on political motives. And we have all witnessed, have we not, in the recent years, how opposition figures, and I will not name them here, have been subjected to a barrage of provisional charges, only for these to be struck down by the courts months or years later due to lack of evidence. Secondly, members of the government or their associates could be shielded from scrutiny and prosecution. Again, we have seen how investigations into prominent figures of the previous administration have stagnated to the point of near abandonment. Madam Speaker, as Attorney General, I do not stand before this House to engage in partisan politics. Let it be very clear. But I would be derelict in my duty as a government's chief legal advisor if I fail to highlight these serious transgressions and to put forward how we can ensure they are never repeated. To avoid these dangers, these two dangers I've just highlighted, it is crucial that the government truly allows the police, the FCC and the DPP to operate independently. If you appoint the right people in the right place, give them the means and the freedom to do their job, then, and only then, can you expect inquiries to be fair, irrespective of who is being investigated. It is only then that you can have prosecutions based solely on legal considerations, evidence and the public interest, and it is only then that you can have the rule of law instead of the dominion of men. This, Madam Speaker, is the difference between justice and vengeance. And this is why the framers of our Constitution had in mind, Madam Speaker, and perhaps here a little history at this juncture would not go amiss. Prior to independence, at the Mauritius Constitutional Review Conference of '61, it was decided that the Director of Public Prosecution should be solely responsible in his discretion for the initiation, conduct, and discontinuance of prosecutions. He would be independent of the Attorney General, who would remain the legal advisor of government and a member of cabinet. This put an end, in fact, to the overlap that had existed until then, and which stemmed from the colonial era office of Procureur and Advocate General. The post of DPP was thus formally established through the Mauritius Constitution Order of '64. Its very raison d'être from the outset, Madam Speaker, was therefore to establish a clear and inviolable separation between two fundamental functions of the state, governing and prosecuting. That same year, Madam Speaker, Professor De Smith argued in his Constitutional Commissioner's report that the DPP should be given judicial security of tenure, as was already the case in other jurisdictions. In 1965, at the Constitutional Conference at Lancaster House in London, the principle of prosecutorial independence was further reinforced, and it was decided that only a person qualified to be a judge of the Supreme Court could act as a DPP. After independence, these provisions were retained and enshrined in Section 72 of our Constitution, which provides that the DPP is appointed by the Judicial and Legal Service Commission, ensuring insulation from executive interference. Section 72(3) of the Constitution confers upon the DPP the power to institute, take over, and discontinue any criminal proceedings before any court of law. The framers of our Supreme Law added at subsection 6 thereof that in the exercise of the powers conferred upon him by this section, the Director of Public Prosecution shall not be subject to the direction or control of any other person or authority. This is why, in his plaint for constitutional relief, the learned DPP described his position as being, and I quote, the apex prosecution authority. The independence of the DPP, Madam Speaker, has been consistently upheld by our courts. For instance, in 1994, a full bench of the Supreme Court observed that, and I quote, a distinguishing feature of our Constitution, like that of some of the new Commonwealth countries, is the splitting of executive functions between what one might call political executive, which remains answerable to Parliament, and an independent, non-political executive in specific matters, consisting of, amongst others, the Director of Public Prosecution, the Service Commissions, and the Electoral Supervisory Commission, which are not answerable to Parliament. The purpose of this device, the learned judges continued, institutionally was to insulate certain areas in the conduct of public affairs from political responsibility and control, thus ensuring the autonomy and their autonomy and independence, end of quote. Similarly, our Law Reform Commission in a 2009 report described the importance of safeguarding, and I quote again, the stream of criminal justice being polluted by the inflow of noxious political contamination by segregating the process of prosecution entirely from general political consideration. And for years, statutes have respected this principle, including when the Independent Commission Against Corruption was set up, allowing the DPP to remain truly the apex prosecuting body of our country. That is, until the infamous, ill-reputed Financial Crimes Commission Act of 2023. Madam Speaker, the explanatory memorandum of this FCC bill in 2023 explicitly declared that the Financial Crimes Commission was to be the apex agency in Mauritius to detect, investigate, and prosecute financial crimes and any other ancillary offence connected thereto. That Act therefore provided at its section 4.3 that subject to this Act, the Commission shall, in the discharge of its functions and exercise of its powers, not be under the direction and control of any person or authority. A similar provision is made at section 11.3 for the role of the Director General of the Commission. Here already we'll see how a law passed by a simple majority aims to displace the DPP's constitutional prerogative under section 72 of the Constitution. This purported apex prosecuting authority is to be, as per section 7.3 and sections 10.1 of the Act, composed of commissioners, a Director General, and this is where the important bit comes in, appointed by the President, acting in accordance with the advice of Prime Minister, after the latter had consulted with the Leader of the Opposition. The terms and conditions of these appointments are to be determined by the Prime Minister alone. The possibility of political influence and considerations which endure during the tenure of the appointees is thus clear. The more so as the Constitution allows at section 113 subsection 4 for anyone appointed in such way to be required to vacate their office at any time after a general election held after that appointment. Madam Speaker, of course, a responsible and honest government would appoint to the FCC persons of integrity, and moral independence. Of course, such a government would not try to interfere in the work of the Commission through secret back channels. And of course, appointees do not necessarily neglect their duties under the law to please those who put them in place. But, and this is the big but, Madam Speaker, one does not build a ship for fair weather. It is the storm that must be provided for. The same goes for our institutions and our laws. Their good functioning cannot depend only on the hope that morality and duty will prevail. There must be checks and balances to prevent any temptation to slide into the arbitrary. There must be safeguards for the day when the unscrupulous try to abuse the system, which is why, as we maintain the mode of appointment of the SEC for the time being, and I stress for the time being only, it is critical that the DPP, whose appointment is quasi-judicial, exercise scrutiny over the prosecuting function of the FCC. Unfortunately, Madam Speaker, this is not what the FCC Act of 2023 catered for. As the law stands today, after its investigations, the FCC has the power to institute criminal proceedings. Section 1421 of the Act does pay lip service to the constitutional role of the DPP by stating that the FCC's ability to initiate prosecution is without prejudice to the DPP's power under Section 72 of the Constitution. As such, it is said the DPP can discontinue prosecution in any criminal case which the SEC has lodged. That is what was advocated by and advanced by the bill's supporters in 2023. But Madam Speaker, the fact of the matter, do excuse me, I must confess I've just been appearing before the Supreme Court, so I slipped. I'm very sorry, Madam Speaker. Right. But when the DPP is not put in presence of the file which led to the prosecution, how could the DPP in fact exercise his powers under Section 72 and step in to actually stop the prosecution? It would obviously be not possible. You see, Madam Speaker, the Prevention of Corruption Act of 2002 compelled the ICAC to submit a report to the DPP after the conclusion of an investigation. Such a report had to contain all material information, statements and documents covered during the inquiry, as well as a description of any evidence which was still in the ICAC's custody, and it had to be accompanied by the ICAC's recommendations. This allowed for the DPP to be properly informed of the outcome of the investigation and to be able to assess whether criminal proceedings were warranted or not. And he had the final say on the matter. In stark contrast, Madam Speaker, there is no such provision in the FCC Act. There is no report to be sent to the DPP. He therefore cannot be in a position to appreciate whether a prosecution initiated by the FCC is justified or not. In the absence of any information on a case, how can the DPP exercise his ability to discontinue proceedings or to step in to continue them, as the Constitution gives him the power to do? His role under Section 72 of our Supreme Law is thus severely curtailed, to say the least. Now, the aberrations, Madam Speaker, do not stop here. As of today, if the FCC decides that it will not prosecute because there is no report to the DPP, the latter may never know whether proceedings ought in fact to have been initiated. In fact, none of us would know. He may not even know that an investigation has been stopped. No one would know, not even us, because there is no obligation on the FCC to inform him. Again, the exercise of his powers under the Constitution was thus neutralized. The FCC Act does not stop there, and it goes a step further in its blatant disregard for the Constitution. Its Section 150, Madam Speaker, allows the Commission to compound any offence under the Act or under the Declaration of Assets Act. That is, if an investigation has uncovered an offence, the Commission has the discretion to grant to the offender the possibility of paying a fine or an amount not exceeding the maximum penalty. When this happens, there can be no criminal proceedings thereafter with respect to that offence. In other words, the FCC has the authority to offer to someone, against the payment of a fine, protection from prosecution, conviction before our courts, and jail sentences. And it can do so whenever it wishes to. It has no obligation to communicate on such a decision. That is so wrong. It is true that compounding does exist under a number of our statutes, mainly for offences relating to banking, fiscal and financial offences. But in all of these cases, there is an obligation on the compounding authority, MRA or the like, to first obtain the DPP's prior authorization. The latter can decide that compounding will not do, and criminal proceedings should be initiated instead. The DPP has no such power when it comes to compounding under the FCC Act. What is more, he is deprived of his ability to initiate proceedings of his own against the offender, as Section 150 of the Act prevents any case from being brought against a person who has benefited from compounding by the FCC. Once again, the Director of Public Prosecutions is robbed, and there is no other word, is robbed of his prerogatives under Section 72 of the Constitution. Madam Speaker, this is the situation which this bill addresses. The different clauses of our bill aim to restore the DPP as the apex prosecution authority in our land, including for cases that fall within the FCC Act. Accordingly, Clause 5 of the bill provides amendments to the Financial Crimes Commission Act 2023 so that no prosecution for an offence under that Act or the Declaration of Assets Act shall be instituted except by or with the consent of the Director of Public Prosecutions. The Financial Crimes Commission will therefore have no discretion in instituting or discontinuing criminal proceedings under those enactments. In addition, further related amendments are being brought to the Financial Crimes Commission Act to provide that where the Financial Crimes Commission determines that an investigation should be discontinued, it shall, and there is an obligation there, it shall send a report to the DPP setting out its reasons. Where the director, in another case, if the director does not advise prosecution or any action, he may also require the Financial Crimes Commission to conduct such further inquiries as he considers fit to advise. And thirdly, any offence to be compounded under either the FCC Act or the Declaration of Assets Act must henceforth be with his consent and approval. Madam Speaker, there is also a series of consequential amendments to other statutes in order to erase the act of legislative vandalism that has been made against our constitutional order. Clause 2 of the bill provides for amendments to be brought to the courts with a view to empowering the Director of Public Prosecutions to be the sole authority to determine whether an information relating to a financial crime shall be laid before the Financial Crimes Division of the Intermediate Court or the Financial Crimes Division of the Supreme Court. Clause 3 of the bill, Madam Speaker, provides amendments to be brought to the Criminal Appeal Act to restore the right only to the DPP to make an appeal to the Court of Criminal Appeal against the final decision of the Supreme Court with regard to any offence under the Financial Crimes Commission Act and the Declaration of Assets Act. The Financial Crimes Commission was given a similar right of appeal to the Supreme Court under the District and Intermediate Courts Criminal Jurisdiction Act against the final decision of the District Court or the Intermediate Court with regards to any offence under the FCC Act or the Declaration of Assets Act. Clause 4 of the bill, Madam Speaker, therefore provides for amendments to be brought to the District and Intermediate Courts Criminal Jurisdiction Act to restore that right of appeal only to the DPP. Madam Speaker, the FCC Act 2023, a law passed by a simple majority, cannot trump, no pun intended, the provisions of our Constitution. It cannot be allowed to curtail the prerogatives of the DPP under Section 72 of our Supreme Law, and it most certainly cannot contravene the principles of democracy enshrined in its Section 1. The passage of this bill today is not simply a legislative correction. It is a moral obligation. It is a declaration that our institutions are not bargaining chips in political games, that our Constitution is not a plaything to be controlled at will. It is a message to our citizens that they can once again believe in the fairness of our law and the impartiality of our justice system. Madam Speaker, through this bill, we do not merely amend a law. We seek to restore justice, reaffirm democracy, and recommit ourselves to the ideals that make the Republic of Mauritius a sovereign and democratic state. With these words, Madam Speaker, I commend the bill to the House.
You're seconding the bill. Dr. Bouler is seconding the bill. Okay. So now I will call on the Honourable Leader of the Opposition.
Merci, Madame la Présidente. Merci de me donner l'occasion d'intervenir cet après-midi sur ce projet de loi, c'est-à-dire le Financial Crimes Commission Miscellaneous Provisions Bill. Madame la Présidente, c'est un projet de loi selon l'explanatory memorandum qui propose des amendements afin de donner le pouvoir au directeur des poursuites publiques d'entamer des poursuites ou de ne pas donner suite à des enquêtes effectuées par la Financial Crimes Commission. Madame la Présidente, l'ancien gouvernement avait, avec raison, mis en place la Financial Crimes Commission afin de créer une autorité de régulation indépendante pour la mise en œuvre des mesures strictes de lutte contre, premièrement, le blanchiment d'argent et le financement du terrorisme. Et cette commission, Madame la Présidente, avait permis à l'île Maurice de faire face à ces défis spécifiques dont on était confronté en tant que centre financier international. Et la mise en place de cette commission souligne l'importance de la coopération et de la collaboration internationale dans la lutte contre les crimes financiers transnationaux. À l'époque de la création de la FCC s'inscrivait également dans le droit fil des engagements que nous avions pris avec le groupe d'action financière GAFI, selon lesquels Maurice va continuer à se doter d'institutions fortes pour mener une lutte sans relâche, Madame la Présidente, contre toute forme de transaction illicite qui transitait par notre centre financier. Alors, l'objectif de l'ancien gouvernement, avec l'introduction de cette loi, était en finalité, Madame la Présidente, d'améliorer la réputation de notre île comme une juridiction propre et transparente. Et aujourd'hui, Madame la Présidente, le présent gouvernement propose des amendements pour redonner le pouvoir au directeur des poursuites publiques d'entamer les poursuites après les enquêtes de la Financial Crimes Commission. La question qu'on est en droit de se poser cet après-midi, Madame la Présidente, c'est est-ce que ces amendements apporteront des meilleures retombées dans les enquêtes contre les crimes financiers ou est-ce que cela ne va pas retarder les poursuites? Le temps nous le dira, Madame la Présidente. Je note d'abord, Madame la Présidente, que ces amendements visent uniquement à restaurer les droits de poursuite au directeur des poursuites publiques. Alors, Je suis en droit, Madame la Présidente, de présumer donc que le gouvernement considère que le reste du Financial Crimes Commission Act est correct et représente une amélioration sur la précédente loi qui était la POCA et qui était introduite par le gouvernement MSM-MMM en 2002. Et, Madame la Présidente, je pense qu'il est de mon devoir de rappeler à cette Chambre brièvement certaines grandes avancées sous le Financial Crimes Commission Act, à commencer par l'introduction d'une nouvelle définition de property qui n'a jamais existé dans aucune loi avant. Et property a maintenant, Madame la Présidente, une définition plus large qui inclut any right or interest in the property. Donc, même si une personne n'est pas le propriétaire officiel of a property, un intérêt prouvé dans ce property qui est lié au crime suffirait, Madame la Présidente. Il y a aussi cette notion de compensation order. Une personne contre qui un confiscation order ou un attachment order a été injustement émis peut désormais demander a compensation order en cours. Il y a aussi, Madame la Présidente, l'introduction de corruption in private entities et...
Yes, one moment.
My point of order is as follows. The Honourable Leader of the Opposition should stick to the subject matter of the debate. It should not be an opportunity for him to revisit the bill, the debate that took place in 2023. And this is precisely what he's doing, saying there was this, there was that, and there was something else. We're here to stick within the parameters of the bill, and this is what the Attorney General did.
That's what I said this morning.
Yes,
Or this
so let us be
afternoon.
relevant.
Please try and follow.
Yeah, I'm trying to do that, Madam Speaker, but I'm not being irrelevant. We are amending the Financial Crimes Commission Act. Although it is being referred to some specific, the Attorney General himself said that we will come with further legislation.
No, but then you will. Let me. Everybody's a speaker today. Then you will intervene when he comes. It's true that today, c'est très bref en fait, c'est très clair et très net. Donc venez directement sur l'amendement lui-même et non pas sur la loi telle que c'était et qui va peut-être être amendée plus tard. Essayez d'être plus direct, on va dire.
I shall try, Madam Speaker, and I'll be brief also. Let me get back to my speech, because I mentioned some of the specific clauses related to the Financial Crimes Commission Act, which today allows us to be more prudent in what we are doing. Madame la Présidente.
Excusez-moi, monsieur le responsable de l'opposition, le débat, si j'ai bien compris, en plus en tant qu'ancien Attorney General, je devrais dire, le débat est sur la fonction du DPP qui est restauré. C'est là-dessus qu'il faut parler. Vous pouvez ne pas être d'accord, bien sûr, et non pas sur le projet de loi dans son ensemble.
Alors, permettez-moi, comme vous le dites, Madame la Présidente, d'aborder la pomme de discorde alors, de ces débats. Voilà. Et cela concerne les pouvoirs du directeur des poursuites publiques. Alors, permettez-moi de prendre comme référence ce qu'avait dit l'ancien Premier ministre lors des débats sur le Financial Crimes Commission Act en 2023 concernant les pouvoirs du directeur des poursuites publiques. And I quote, "It is to be noted that the constitutional powers of the DPP are not being affected at all. The DPP will retain his powers under Section 72(3)(b) and C of the Constitution and can therefore take over and continue or discontinue at any stage any such criminal proceeding instituted by the FCC. Where he decides to discontinue any such proceedings, he may give reasons as he may deem fit for such discontinuance. However, an aggrieved party may apply to the Supreme Court for a judicial review of his decision. Et je me réfère à ce que l'honorable qui avait pris un point of order tout à l'heure, l'honorable Shakil Mohamed, avait dit et réagi à cette partie du discours de l'ancien Premier ministre. And I quote, "I agree with the Honorable Prime Minister that the DPP retains the right to discontinue proceedings. I totally agree with Section 72(3)(b) and C. Et ici, je n'ai pas de problème avec ça." Je voudrais aussi, Madame la Présidente, revenir sur un extrait du discours, parce que moi aussi j'ai été intervenu ce jour-là, de notre intervenant lors des débats de 2023, et en particulier l'ancien Premier ministre adjoint, Ivan Kolan Davidou, qui évoquait la Prosecution Commission Bill et avait dit ceci, je cite, « Le DPP n'est pas exempté d'erreur. Il n'est pas above the law. » Naturellement, je ne remets pas en question l'intégrité de l'actuel directeur des poursuites publiques, loin de là, Madame la Présidente. Madame la Présidente, après avoir dit ce que j'ai dit, et en restant toujours dans le droit fil de ce projet de loi, je vais conclure, Madame la Présidente, avec un message suivant pour le gouvernement. Vous avez, certes, comme l'honorable Paul Béranger l'a dit tout à l'heure là, vous avez été élu avec une majorité absolue. Et c'est très bien. Mais un peu...
Let everybody have a good laugh.
Yeah.
It's good for the, you can also have a good laugh.
C'est très bien, mais c'est moins bien pour la démocratie. Mais ainsi est fait notre système, Madame la Présidente. Et ce peuple ne souhaite aucun abus de votre part. J'en ai terminé, Madame la Présidente.
Honorable Damri, I think, if I'm not mistaken. Yes.
Madam Speaker, with a copy of our sacred Constitution in my hand, I commend the Attorney General for introducing this bill of massive importance to the financial sector and to the nation. Back in 2023, the proposed enactment of the Financial Crimes Commission Act caused a public row that highlighted the scandalous attempt by the previous government to infringe on the powers of the Director of Public Prosecution. The transfer of powers of prosecution for financial crimes to the newly appointed Director of the Financial Crimes Commission, an officer appointed by the Prime Minister only, was a gross attempt to flout our sacred Constitution and undermine the very foundations of justice. Wielding powers of prosecution to an individual who is not independent is not only anti-constitutional, it is cruel. Loyalty and independence are inherently contradictory. Allow me to quote William Shakespeare in Macbeth. Who can be wise, amazed, temperate and furious, loyal and neutral in a moment? No men, unquote. No men, Madam Speaker, no men can claim to be independent under the circumstances set by the previous version of the Financial Crimes Commission Act. Yet, the previous government chose to push for this provision. They felt emboldened enough to go one step further in the systemic state capture of our institutions. It illustrates the utter disregard for our Constitution, for the democratic principle that we Mauritians cherish, utter contempt for the rule of law. This, Madam Speaker, was the hallmark of the previous government. At the end of 2023, it became very clear that Mauritius was slowly but surely drifting towards autocracy. Prime Minister Dr. Ram Ghulam knew too well the risk of a biased Financial Crimes Commission applying arbitrary charges on Mauritians of all walks of life on the ground of diverging political opinion. He himself has been a victim of a political vendetta. You will recall, maybe not many of you know in this House, that Prime Minister Dr. Ram Ghulam joined politics for a cause, to fight for justice in the courts and in all spheres of life. He fought to maintain the Privy Council as the highest court for Mauritius, sparing the country from threat that an autocratic government would infringe on the judiciary and deprive Mauritians of a fair justice system. It is in his DNA to fight to restitute the full powers of the DPP. In the light of the past experience of the previous government, it became obvious that the only route to restore the systems of checks and balances in the financial system was to kick the previous government out of office and its MPs out of parliament. The people of Mauritius voted intelligently. This, Madam Speaker, is such a relief. I still wonder what drove the previous government to hijack the democratic system prevailing in this country.
Yes, one moment.
Yes.
Order. Yes?
Yes, I believe the Speaker is being very relevant.
Yes, and also you're reading from your paper. Try and come and talk on the bill, please.
Yes, I think I am speaking about the powers of the DPP at the moment.
Well, try and...
Yes. Okay, I'll be... So, perhaps it was the illusion of isolation. Being on an island, they assumed that catastrophic mismanagement would escape international scrutiny. While we were producing this glaring loophole in our financial legislation, Madam Speaker, the financial community was ringing alarm bells. Madam Speaker, in his address, the Honourable Leader of the Opposition stated that the 2023 Act was passed to strengthen our financial services sector. That's what the Honourable Member said. So let's analyse his statement for a moment. World over, governments are reinforcing their legislation to curb the flows of illegal finance and consolidate the trust in their financial system. The track for illicit funds and illegal financing cuts across borders and jurisdictions. When our Financial Crimes Commission Bill was voted, Mauritius had just been able to untangle the threads of the Financial Action Task Force, FATF, that were choking our global business sector. The last thing we needed was another blow to our reputation. A law that allowed some financial crime could go unprosecuted and therefore unpunished. Did it occur to the previous government that this legislation was about to weaken the fundamentals of an economic activity that accounts for 15% of our GDP? Did they even consider the impact of a poor legislation on the much-needed flow of foreign currency that keeps our balance of payment afloat? Was it an overconfidence bias or just sheer incompetence that led the previous government to believe that the integrity of our financial center would not be damaged from such obvious flaws in our laws? This is not mine to answer. I am just happy that we are now undoing the process and restoring trust and confidence in our jurisdiction for the benefit of all Mauritians. As we are turning the page on this sad chapter in our legislative history, it is time to look forward and think of what we would like to build for the future. In our program, we said we wanted to build a bridge to the future. Yes, we are restoring the powers of the DPP in the matters of financial crime. Our goal is to ensure that in the future there is manifest independence in the conduct of prosecution, of all prosecutions. Luckily, we are not the previous government. We are not a bunch of mindless, power-hungry politicians. Otherwise, we would have already used the provisions of the present Financial Crimes Commission Act to put charges on the previous government's leaders and their cronies. It would have been so easy to do it, but we chose not to. We didn't do it because we wanted to show that we are faithful to the spirit of the Constitution, faithful to the ideals of our founding fathers. We want the public to see that we mean business when we say that imported prosecution decisions will be exercised on strictly neutral grounds. Meanwhile, Madam Speaker, there are numerous suspicions of financial crimes from the previous government that the public would like to see brought to court. Understandably, the public is impatient, thirsty for accountability, but the public needs to know that any proceedings will be carried out with fairness and impartiality, as we pledged to do. We are building a system that is made to last, not a short-lived framework to mark a political transition. With this, I commend the Attorney General to bring the bill to the House. Thank you.
I will suspend the House for about half an hour. Half an hour. Let's say 4h30, 5h. 5 o'clock.